A big case did come down from the Supreme Court today. It was the Arizona immigration law. The judge, Andrew Napolitano, is here.
Stuart.
Now, one thing that we've reported so far is that in future, the police will be allowed to ask people that they stop for traffic violations for their immigration papers. But what else did the court rule?
The guts, the heart and soul of this Arizona statute, and also of companion statutes in other states like Alabama, which were not strictly speaking before the court this morning, is that when the federal government fails or refuses to enforce federal immigration law, the states may stand in the shoes of the federal government and enforce it themselves. That was the theory behind the Arizona statute. That has been struck down.
That's been struck down?
Correct. The Supreme Court has basically said, with respect to immigration, and I'll tell you why immigration is unique in a moment, the states may not do this. Immigration is unique because the Constitution specifically grants to the Congress, and thus to the federal government, the power to regulate immigration, and the Congress, by the manner in which it is regulated, has preempted the field. Stated differently, has decided that only it, the Congress, can regulate the field of immigration. Of course, we know we have a president who thinks he can rewrite the laws that Congress writes with respect to immigration, but that's another issue for another time. But basically, the court is saying, even if you have an immigration problem, and even if the feds won't enforce the law, you can't take the place of the feds. You can vote them out of office, but you can't take the place of them because the Constitution is clear. Only they, the feds, can regulate immigration.
Earlier, Charles was saying this brings to mind states' rights. And that we thought, collectively, we thought that these court rulings were limiting the federal government's power to regulate the states. But you're saying as if it's the other way around.
Well, with respect to Charles's observation, I cannot disagree. I am loath to disagree with Charles on anything. But here's why. It's a very interesting argument Justice Kennedy makes in the majority opinion. This Section 2B, letter B of the statute, which the Ninth Circuit enjoined, which the Supreme Court said shouldn't have been enjoined, basically says if you stop and arrest somebody for something having nothing to do with immigration, one of your jobs is to find out if they are wanted on a warrant in this state or another state for another offense. The statute also says you can go one level deeper and find out if they are a lawful resident of the United States. You can't stop them because you think they're an unlawful resident. That's been thrown out. You can't stop them for an immigration purpose under the pretext of it being something else. That's been thrown out. But if you have lawful custody over someone for a lawful non-immigration arrest, yes, you can do the research and see if there's an immigration problem as well. Now, I'm smiling because here's where the lawyers come in. Probably this afternoon, someone will be stopped for jaywalking or speeding. And probably this in Arizona, and probably this afternoon, an Arizona police officer will go into his computer and see no record of this person. So I'm going to detain him until I can find out if he violated federal immigration law. And probably this afternoon, this person will hire a member of your favorite profession to challenge the application of this section against that person. And probably next year, this will be back before the Supreme Court.
Is this a victory for Attorney General Holder?
It is a victory for the Obama administration and a profound defeat for Governor Brewer. However well-intended you may believe Governor Brewer was, however intense and intractable the illegal immigration problem has been in Arizona, this is a setback for states trying to enhance the sovereignty of their own borders when the feds won't do it for them.
I was asking earlier, in the Knox versus SEIU, 7-2 ruling in favor of Knox against the unions. Then we had the ruling in Arizona, where you are allowed to ask people for their immigration papers. Then we had the ruling in Montana, where any limits on corporate contributions to financing political campaigns struck down.
Right.
All of those seem to me to be on the conservative side of the ledger, which makes me think that maybe when we get the ruling on the mandate, the conservatives will win, and that mandate is toast. And you say?
I don't think there's any way to predict what the Supreme Court is going to do on Thursday on the basis of what came down today. But independently of what came down today, I think the Supreme Court will invalidate the mandate. But Stuart, I promise you this, we'll know by this time on Thursday morning.
Yeah, definitely.
I think so, yes. I happen to believe that some members of the court have other commitments the week after next. Just sort of a guess, and they may not be around come the 4th of July week.
Judge, we heard after they heard the case that they made the decision a long time ago Now, I know they had the right to change the decision, but would that be the case? I mean, wasn't this already in the can, so to speak?
Yes and yes. Yes, they made the decision a long time ago. Yes, if it's 5-4, that can change depending upon the wording of the opinion. It may be necessary for the original 4 to give some concessions to the 5th vote in order to keep that vote. That happens until the ink is dry, Charles. It could even be happening as we speak.
Wow.
All right, Judge, you know what you're talking about. And we
It's
appreciate
such a pleasure to hear you say that, Sir Stewart.
You're welcome. Talk's cheap, Judge. Come on, everybody. Let's